In terms of business law, this particular next unit floor, there's really two distinct components to this unit. This unit looks at something called agency. And what agency is effectively, it is someone who represents you, or if you're a corporation, some person that represents you, the corporation. So you are an agent for. Okay, you're representing, you have a legal obligation or a legal right to represent that individual or that corporation. So agency law, as you can imagine, has a lot of implications for business and a lot of implications in terms of legal responsibilities and the like. So we're going to look at that. The second part of this deals with business structures. And business structures is important because what it is you set up a business. It could be a sole proprietorship, could be a partnership, or it could be a corporation. And all of those business structures have legal implications. So we're going to take a look at that. So that's what this business law, this is really like the law of doing business. This is what this particular unit is really focused on, is how do we cover off those things from a legal point of view and be aware of some of the legal niceties with regards to it. The resources for this part of the unit, for the particular textbook that's cited in this course, it's chapters 15, 16, and 17. But if you have another law textbook, introductory law textbook, because as I said many times in this course, every one of these introductory law textbooks cover exactly the same topics. So it's just a matter of finding the chapters that relate to the material. And the material, you will see the terminologies on them are exactly the same in every single course. So agency, for example, is usually a chapter in a law textbook, as is business structures. First part deals with this issue of agency. And in this unit, we're going to explain the roles and limitations placed on agents. We're going to look at the liability of what we call principals, which is the you or the corporation that hires an agent. So the principal is considered the individual that is being represented or the corporation that is being represented. Okay, so we use the word principals there. And the agent then is the person who represents the principal and has the power, certain legal authority to make contracts and the like for that principal. And we're going to describe this thing called a fiduciary duty. Fiduciary duty is the obligation of the agent or the obligation of the principal to the other. So the agent's responsibilities to the principal and the principal's responsibility to the agent to act in their best behalf. So an agent, by definition, is a person who represents another, and the other is called a principal, in dealing with a third party. So we've got this triangle set up where you have the corporation or the individual, you have an agent who represents that corporation or agent, and you have someone that they're contracting with. So that person can be an employee, which gives that person certain legal rights, and we've talked about this concept of vicarious liability already in this course. Or it could be an independent contractor. So for example, if you think about insurance agents represent an insurance company, and they act on their behalf, and they contract insurance policies on behalf of the insurance companies. But they are not employees of insurance companies. They're what's called an independent contractor. We're going to look at this concept of employee versus independent contractor when we move into, we're going to look at it more fully when we move into the employment unit. And effectively, what the agent's job is really, whether it be an employee or an independent contractor, the job of the agent is to enter into contracts on behalf of one another. So they're going to basically, an agent is responsible for writing contracts that's going to bind the principal to something. So it could include services such as filing documents or negotiation of a contract. Could be any number of things. In terms of creation of an agency is created when a principal grants authority to the agent to act on his or her behalf, usually by contract. So what we have is, in the case of employment, we have an employment contract, for example, where the principal says to the agent, Here are your rights and obligations and your duties. Okay, here are the things that you're going to do for me. You can set me up in contracts, you can sell products I own, you know, these sorts of things. It could be created what's called gratuitously, meaning that there's no real formal contract, but the actions of the agent and the actions of the principal in terms of, okay, the agent goes out and sets up a contract for the principal hasn't granted them authority to do that, but the principal agrees that, yeah, this is in the best interest, I'll carry through with it. That's what we mean by gratuitously, meaning that there's no hard rules say that he should have done that, but the principal agrees with it. And it could also be inferred by the conduct of the parties. If everyone agrees and carries through with it, we could have what's called an agency agreement. The problems with agency, or the challenges from a legal point of view with agency, is we run into this issue of authority. How much authority does the agent have to bind the principal in contract? So let's say, for example, let's go back to clearing snow again, okay? So I clear your snow. We have a contract for $10. I will clear your snow, okay? Now, I'm just so busy that I don't handle the dealing with you directly. I have a person who does that for me, an office person, okay? So you phone my office person, you say, well, I'd like Paul to come and clear my driveway for $10, and that person says, okay, yeah, we'll get Paul to do that. So effectively, you and I haven't discussed it. You and I haven't talked about it. You and I have not had a direct contract. There's nothing on the go, but you've spoken to my representative who has said, yeah, Paul will do that for $10. So Paul has basically agreed to the contract, not through Paul, but by some other third person. That third person then will be called the agent who is acting on my behalf. Now, the thing is, from my perspective, I am employing that individual, okay? I'm going to employ that individual. And I will say to that individual, okay, here's what I want you to do. I want you to take phone calls from people when they call in and they want their snow plowed. I want you to take their names, make them aware how much it's going to cost, and you tell them, yes, I will clear their driveway. So effectively, what I've said to that person in the office is, you can make contracts on my behalf. That's effectively what I've said. You know, the price is there, the time is there, all of the components that would be in a normal contract. However, I'm not having anything to do with it directly. I'm getting that person to do that. So if I said to that person in the office, that's what I want you to do, I have more or less given that person authority to contract on my behalf. And I have clearly indicated that if someone calls in for snow clearing, that is what their job is. So they have what's called expressed authority to contract on my behalf. So you call up, Paul, come plow my driveway, $10. Yep, okay, Paul will do that tomorrow. Great. There's the contract in place. The person that I put in the office doing that has set up the contract for me. And if I don't come and plow your driveway, you can sue me because I did not live up to the contract. And I can't argue that I didn't have anything to do with the contract because I had a person, an agent representing me, who set up the contract. So I'm still obliged to complete the contract. Let's take it, for example, a step further. Instead of plowing your driveway now, you call up that person and you say, well, I want Paul to dig a ditch for me. And I need the ditch to be 100 feet long and 6 feet deep and da-da-da-da-da. And that person on the other end of the phone, my agent, we'll call him, says, yeah, for $1,000, Paul will do that. Okay, great. Now, here is the problem. The problem is, in my mind, I have said to that person behind the desk, if someone calls for snow clearing, here's what you do. You say to them what the price of it is, you schedule the time, and I will go do it. I did not tell that person that if someone calls up to dig ditches, that we can set up a contract with them. I have not given that person the authority to sign contracts on my behalf for digging ditches. So there's a distinct difference, okay? I have in my mind, as the employer, I have clearly indicated that's for snow clearing. That person has gone and bound me for beyond snow clearing. Now, there's a couple of things I could do. I could say, no, I'm not going to do that. And that could create some problems for me, because that person, if you're the one that called in, and spoke to that person and said, I want the ditch dug, and that person said, yep, Paul will do that for $1,000. As far as you're concerned, in your mind, that person has bound me to dig a hole for you for $1,000. In my mind, as the employer of that person, I do not have the means, nor have I told the person on the desk that I will do that type of work. So I'm in a little bit of a pickle, because you have made an agreement with me to dig a hole that's $1,000 for work, and I'm thinking I don't want to do that. So as far as we're concerned here, the authority of the individual who is binding me to that contract has been overstepped. I have clearly indicated that person snow clearing only. That person has gone beyond snow clearing, so I'm not happy. Now, you don't know anything about that, nor should you. It's not your concern. You called up and you said, ditch digging, $1,000, got a deal. So I'm the one with the problem. And really, it is my problem, because I need to clearly say to that person, here are the confines of the work. Now, the trick is let's say, for example, that is not the first time that's happened. And let's say it's happened 10 times before, that type of thing, where it's a non-snow clearing related bit of work, and I've gone ahead and done it. Could I argue that that person on the front desk has outstripped that person's authority? No, I can't, because I have given that person what's called implied authority to contract me to go beyond snow clearing by the very fact of my actions. My actions are that I have done work before that is beyond the scope of snow clearing. So my implied authority to that person has stretched. So even though I haven't specifically said to that person, I only do snow clearing, even though I haven't said to that person I will do more than snow clearing, my actions have indicated, yes, I will do more, and that they can contract me to do more. So as an employer, I have to be very, very careful to ensure that I clearly indicate to that individual what the limits of their authority is, because I will end up in a little bit of a pickle if I say to that person, no, I'm not going to dig a ditch, because I don't do that, and that person false bounded me. I'm going to be because the implied authority has been given. We went to court. I said, no, I'm not going to do it, refused, and you sued. Then there could be a bit of a problem. Now, we also have this term, apparent authority. From talking to one of your relatives who say had work done by me before, that I dug their ditch, right? So you think then that, I do this type of work, and that person that was on the phone never questioned whether I do that type of work. So as far from your perspective, they have what's called apparent authority. So the principal does something to lead the third party to think that the agent has authority. In the past, I've allowed that person to go make contracts for me. That's happened. Here we go. That's what's called apparent authority. So we have to be clear on the three types of authority. We got expressed authority, which is officially what I've told my employees they can do, what they can contract to. That's what that's the bounds of the limits of the employee's responsibilities are defined by me, the employer. If that got stretched, and I agreed to do the things without any concern, I didn't speak to the person to say anything, then what we have is a bounding that is beyond the bounds set in the express authority. The bounds go on to what's called an implied authority. Let me just go out. Oh, go out to here. So we've got this expressed authority is, let me get my little thing here. The expressed authority is what I've officially told the person they can do. The implied authority is, well, I've kind of done what that person has bounded me to do. And the apparent authority is from the respect of the buyer or the person who comes looking. Apparently, that person here in the office can say that Paul does this type of work, and apparently, as far as you're concerned, I do that type of work. And so we see the bounds being stretched in each of those. So the expressed is what I say, implied is what I do, apparent is what you think. So this is the authority, and beyond that, there is what's called no authority to go on. So we should be familiar with the three types of authority. Now, there's a legal term called estoppel, which prevents an employer from denying someone has authority. And this is where we get into, I say, well, that person contracted me to do the ditch digging. I never gave that person the authority to do that, so I don't want to have to do this. Well, the court's going to say, well, all your actions in the past, Paul, you've done it before, all your actions in the past led that person to believe that they did have authority. So estoppel basically prevents the employer from denying someone has authority. And where the principal does something to lead the third party to be reasonable to believe that the agent has authority to act, the principal cannot later deny such authority. So, if my actions in the past, as verbalized by other clients, say that I do this type of work, and that the agent has booked people to get the work done before, all things pointed to the fact that I do that type of work and that I would contract for that type of work. And that is exactly what the court is going to say you do, buddy, because all indications are that you do that sort of thing. We also bring in this concept of ratification. So where agent exceeds both actual and apparent authority, the principal is not bound but may still go ahead, ratify the agreement. So let's say it's clear that the agent exceeded both the actual and apparent authority. So just go back to this one here. The actual authority is what I told that person I would do. The implied authority is what I have done, and the apparent is what you as the buyer perceived I do. So if the agent went beyond this boundary, okay, with beyond this boundary, so I started off with snow clearing, now I've moved to ditch digging, and now I'm going to building buildings, okay? So let's assume that the agent has bound me to build a building. So I'd clear the land, dig the ditch, and build a building. Well, I'm not into the building business. One thing that I can do is, I can argue that, no, that's beyond the extent of what I do. And the agent had no authority to bound me on building houses. No one's ever seen me build houses before. I haven't done it before. Great. On the other hand, the other option is I could do what's called ratify, which is say, okay, I'll build a house too. So I may go and build a house and say, yes, I will build a house. So I may ratify intentionally by expressly ratifying. In other words, I say to you, yes, I will dig the ditch and build a house. Or I may ratify inadvertently by the principal taking some benefit under agreement. So you paid me $10,000. I took the $10,000 knowing full well that it involved building the house. I can't, I've taken the benefit of it, so I can't turn